always say. You put us in the waiting room past time? Absolutely, Linus. Let's go ahead and get started on. Let's go ahead and jump into an old Judge Boyd one. She hasn't done any live streaming this year. It's got everybody kind of curious of what's going on. So let's see what's going on there.
All right, court is calling 2024 CR 1619 State versus Felipe Lopez. Can I have parties announced for the record for the state? Defense?
Christopher Castro for the defense, supervising attorney for student attorney Nicholas Asaro.
Oh, Nicholas, you want to make your announcement for the record?
Yes, Nicholas Asaro.
Right. You need to say Nicholas.
Asaro for the defendant, Felipe Lopez.
Right. Did you understand the state is proceeding on the lesser included offense of terroristic threat as a Class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
All right. After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding you guilty as you apply for deferred adjudication. Are you proceeding in sentencing?
Yes, Your Honor.
Yes, sir.
All right. Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Lopez was in this situation. He was being bullied at school, Your Honor. I would like to say that the state's exhibit number 1, which tags the high school, was not actually done by Mr. Lopez. It was a story he shared and then shared by another student that tagged the school. So that may be a little misleading based on the picture itself. But he did not tag the school itself in that exhibit. I just want to let the court know.
Thank you. How old are you?
19, Your Honor.
All right. You're 19. So, and I'm assuming this person, Santanella, was that your friend?
Who, Your Honor?
Joe Santanella. I know I'm Santaniana. It's 2 L's.
Santayana.
Was that your friend?
No, sir. No, Your Honor.
He's never been your friend in the past. All right. So who was Victoria to you?
Just somebody that we knew through Joe.
I'm sorry?
Somebody I knew through Joe.
All right. So everyone, we're on the record. Don't talk behind the court reporter. So that's someone you knew?
Yes. Yes,
All
Your Honor.
right. So it seems from reading the reports that it was more than just someone you knew. This was sort of like a love interest between the two of you.
Yes, Your Honor.
All right. So here's the thing. You need to be 100% honest with me. You understand?
Yes, Your Honor.
So I don't know why people who are in high school or in middle, well, I don't even understand the dating, serious dating in middle school. I guess I'm aging myself. That just was not allowed. But when you're in high school, maybe it's the love of your life. Maybe y'all going to end up getting married. Maybe not. From what I've seen in this world, usually those are just, we're just dating. They're just experiences. And then you move on. You understand?
Yes, Your Honor.
She doesn't want you in that way. I don't think she wants to speak to you at all. So you're not allowed to talk to her. Do you understand?
Yes, Your Honor.
Are you still going to this high school?
No, Your Honor.
All right. And Joe, don't want to speak to you. You're not allowed to speak to him at all. You understand?
Yes, Your Honor.
And here's what I can tell you. When you have a relationship and your best friend starts dating the person you're in a relationship with, usually that's not your best friend. That's not a friend. Because if that person were your best friend or your friend, they would tell the other party who wants to date them, no, another time, another place. It's like Erykah Badu, see you next lifetime. I'm with somebody else right now. You understand?
Yes, Your Honor.
So you're going to be hit with a lot of things in your life that you think are not fair, but you got to roll with the punches and keep going forward. You don't put stuff in writing. You understand?
Yes, Your Honor.
And in your writing, you're using the N word. I bet you were shocked when you saw me here. Right?
Yes, Your Honor.
So this is what I was always told. This is what my mother's teacher told her when she was in school back in the 50s. You know what she always told them? Don't ever put anything in writing that you don't want the entire world to see. You understand?
Yes, Your Honor.
Now, the fact that you're using the N word, I'm not holding that against you. Young people are just doing crazy, stupid things. That is not an appropriate word to be using. Do you understand?
Yes,
I don't care what people are doing in rap or whatever. MC Light said that she was shocked when she went to a club when people start calling females the B word and using the N word. She's like, when I started out in rap, people were not using that language. Not good language to use. Do you understand?
Yes, ma'am.
And it's not good to make threats against people. When your heart is broken, I don't care if it's breaking in 1,000 pieces and you want to cry. Guess what? The person who broke your heart, just look in their face and smile, and then go back to your room, go talk to somebody that you know, your mom, your dad, and cry it out there. You understand?
Yes, ma'am.
Are you employed?
Yes, Your Honor.
What do you do?
Construction, Your Honor.
All right. What are your plans for the future? What is your dream job?
Construction, Your Honor.
Oh, well, look, you're on a great path. You're already doing what you want to do. How far did you go in school?
11th grade, Your Honor.
All right. You're going to have to graduate. Okay.
Yes, ma'am.
And then if you really want to be in construction and hope to move up, sometimes people will be in construction and things will fall into your lap. Next thing you know, you're owning a company. Education never hurt anybody. If you want to end up owning your own company, you can, but you probably should take some business classes. You understand?
Yes, ma'am.
All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. There's to be no fine. There's to be regular reporting by Zoom or in person. There's to be regular random UAs. There's to be no contact. I'm going to order 80 hours of community service restitution. If you obtain your GED or if you obtain some type of trial, trade school certificate, or if you take a business course, I will deem those community service hours satisfied. Do you understand?
Yes.
All right, we can go off the record. Thank you so much for dressing appropriately for court. And what is your name again?
Nicholas Asaro.
Nicholas
Asaro?
Asaro?
Yes, ma'am.
All right, everyone, this is a student attorney, Nicholas Asaro. Give him a round of applause. He did great. Come in anytime you want to. What level are you at in school? A 2L?
So 3L.
3L. Oh my gosh, you're almost here. All right,
Yes,
thank you. So what will happen is probation will speak to your client and go over conditions with them, and then you all are excused.
Yes, Your Honor.
All right, thank you.
Good morning.
I guess I'm supposed to talk in between some of these, so thank you, Nancy. Thank you, Nancy. She jumps in and distracts me by gifting a membership. Thank you so much. I appreciate it. This is a couple of old ones, trying to get through the holiday season, trying to find stuff that's still interesting to me. Some of these cases are pretty awesome. It's good to see how some of these work out. Judge Boyd catches him using language he wouldn't want to see in court and kind of lets him know the dangers of using language that you don't want to see in court. And so we're going to jump into a Judge Middleton one, and we got Judge Simpson at the back end of this one. So let's see where we go with here.
Good morning.
Are you Teresa Bradley?
Yes, I am.
All right, very good. This is Judge Middleton. You're in the right place. We
Great.
have about 1 minute until we're set to begin. I saw that you'd practiced logging in. I appreciate that.
Yes, I've never done this before, and
Well,
I'm
some
not very
people
good at
practice
this stuff.
1 minute before it starts, but you're doing fine. I can see you and hear you, and your microphone is turned on. And Zoom wasn't a thing till a few years ago. Now it's ubiquitous.
Yeah. Very nice. I just worked all night and just got home. So it's nice to be able to do it in your own home.
Yes, that is the upside of it. There's some downsides, but you won't have to drive to Centerville, and we can take care of our business here,
Yes.
which is a bit odd. All right, it is 8:30. I'm going to call this case.
Okay.
Titled Teresa Bradley versus Jessica Beal, Apartment A and Apartment B. Is this a duplex?
Yes, it is.
There is no lease. Is she related to you?
She's my daughter, and my 4 grandchildren also live there. It's a
I think she's here.
2-bedroom. Okay. It's a 2-bedroom, so it's very small for a mom and 4 children. She's actually in my kitchen on her phone.
Oh, good. I didn't know if I was in the right room. I'm gonna go home.
All right.
Okay.
Are you Jessica Beal?
I am. Sorry, my Zoom isn't working on my mobile device.
All right, we'll make it work. You're the other Jessica Beal. It's spelled B-E-A-L.
Yeah,
This is a
That's the one
termination of
here.
tenancy case that the landlord, who's your mother, wants you to move. So I'm going to take a minute and tell you what your rights are as a tenant. I have to do this in each case, and which is all right. As a defendant in a termination of tenancy case, you have the following legal rights. You have the right to obtain representation, meaning counsel for this matter. If you cannot afford an attorney, a legal aid attorney may be available to help you, and she should be joining us here shortly. There is no court-appointed counsel in civil cases like landlord-tenant. You have a right to a trial by a jury or by the court. If you do demand a jury trial, you have to do it today or do it within 5 days in writing and pay the jury demand fee of $50 unless the judge waives it. You have a right to have your case heard here in St. Joseph County where the property is. This is not about paying rent. This is about moving. If you're able to reach an agreement with your landlord, meaning the case would be dismissed, we could help you prepare a conditional order of dismissal. And if both parties are interested, we could refer the matter to mediation for an attempted settlement. This is a family situation. I've had a number of these lately. I've probably had 25 or more of these this year, where grandmother, grandson, father, son, brother, there's no lease, they're living there, and the other party wants their property back. So Ms. Bradley, you're simply requesting that she move?
That's correct. And she's actually just found housing has come available. So that was a question that I also had. I don't want to mess up her ability to get this 3-bedroom apartment that is coming up. But should that fall through, I just wanted to, I didn't know what I should do. So that's why I was trying to do it this way. Just so there is that as well. So I think that
All right,
we
well,
are getting
let's-
somewhere.
Where's the apartment, Miss Beal? It's very hard to find. And
They're very
there's a
hard to
waiting
find.
list at Enchanted Glen and other places. Well, here's the story here. The law requires that I adjourn this at least 7 days, which would take us to next Friday, the 25th of October. Then you get 10 more days after that, which would take it to November 4th. So if you move, she can simply dismiss the case. But I think our safest bet for now is to adjourn this matter for 1 week.
Yes, because I don't have they've only verbally promised me the apartment. I've been on this waiting list for 1 year. I have been desperately working to build a business while also living with chronic illness as a single mom of 4 children. And I am doing everything that I can do. There is no housing available. There is no way that I can go and work for someone else when I can charge $300 online as a best-selling author and a publisher and a life coach and a business strategist. But building a business takes time, and my mom is frustrated with that. I have given her money, copious thousands of dollars anytime that I have money. So I'm not in a hurry to move out. I'm fine with taking this to trial. I'm fine with buying as much time as I have to protect my children and I until I can find safe and affordable housing for myself and my family. Because the other option is that I'm living in my car.
Yes, and that's often the problem. The parents or grandparents or siblings aren't required to provide free housing to their kids. It's often a tough situation. Sometimes the family, they want to sell the house and they need to get the people out of there. And that's what this landlord-tenant, it's called summary proceedings, is about. Basically, it's the judge forces you to move out or the sheriff will do it. But I do feel your pain. Good morning, sir.
Good morning.
Let's just have a seat. Every week, twice a week, Monday and Friday, people tell me I would move out if I had somewhere to go to.
Right.
Particularly if you don't have any money. So
Yeah.
the first thing we're going to do is we're going to continue this to next Friday. Miss Bradley, the law requires this. It didn't used to, but when COVID hit, they changed all the rules. So you have to grant one at least 7-day adjournment. So I'm going to continue this to October 25th, 2024 at 10 a.m.
Okay.
for the second hearing. At that time, Ms. Beal, I would have to give you at least 10 days to move. And if you didn't move by that date, then the sheriff could come put you out. That's if your mother got what she asked for. Let me ask a couple of questions. Is this a duplex?
Yes,
Who's paying the utilities?
I am.
Well, actually, I'm paying the utilities, and then the utilities on her side weren't paid for, and the water pump is
In
on
my
that
name.
side. So I
So
had
They
to
were in my name
All
though.
right, so,
and then I put it in my name. So they're both in my name. And right now she currently told
But
me
I've
that she
still been
can't pay
paying
for it.
just a minute,
I
only one
did.
person can talk at a time. So Teresa, you're paying the utilities?
Yes.
No,
Is
Mom,
there any
that's a
rent?
lie. You have never paid
All right.
my utilities in 3 years.
Jessica, I'm paying my
All right, stop,
utilities.
Mom, you're lying.
Stop. I'm embarrassed for both of you. Jessica, you're gonna need to move out of your mother's house. That's just as way it is gonna be.
I know.
So I don't have a
I'm
better.
paying my utilities. I have proof that I'm paying my utilities.
Well, this is not about payment. It's about termination of tenancy. There is no lease. And the plaintiff gave you a notice to quit quite some time ago, back in July, saying that they wanted the property back. And they gave you until August and you didn't move, and then they filed this action. So this didn't just sneak up on everybody. It's been in the offing for a number of months. And this
Well, you asked who's
process.
paying utilities and she just lied.
All right, well, all
And
right.
I have
don't
proof that I'm paying my utilities.
All right. Why don't you bring that with you next week?
Absolutely.
All right. At any rate, I guess I don't need to step on any more landmines. We're just going to deal with this next Friday, October 25th at 10 a.m. And at that point, unless there's some other defense or something I don't know about, Ms. Beal, you're going to have 10 days from that day to move. So we'll discuss this further next Friday. All right. Thank you.
Thank you.
I'll give you.
Court calls case of the people versus Carla Berg.
I'm gonna have to look up October 25th at 10 a.m. I didn't ever remember seeing the follow up on it, but I've got all of Judge Middleton's, and I'm sure I could find it online somewhere. So I'm gonna look that up, see if I can't find that one. If anybody ever knows how that resulted, let me know. I'm fairly certain it resulted with her getting kicked out, or at least I hope it did. But we got Brecken here, so we can go to Judge Simpson. This was another little fun one he had.
Advocate on behalf of Ms. Bird, who approaches.
She's waiving her right to preliminary examination.
That is correct, Your Honor, and we would like to respond at the appropriate time.
Briefly, you'll be able to respond. Ma'am, you're waiving your right to preliminary examination?
Yes, Your Honor.
You understand that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right. Preliminary examination having been waived, defendants bound over on both counts. Your turn.
Oh, thank you, Your Honor. I'm sorry. I was just writing that down. We acknowledge receipt of information. Wait formal reading, stand mute at this time.
Defendant every way formal reading standing mute. Court will enter a not guilty plea. Pre-trial will be set for
October 29th at 1:30 before the county.
October 29, 2004, 1:30. As to bond.
As to bond, Your Honor, my client provides that she would be able to stay at Travis's stepmother's home in Clinton Township. She gave me an address for that. Mr. Bogan, I'm sorry, Travis. Travis is no longer in the area. He went back to Georgia. I know that when we did the violation hearing, some of this stemmed on initiation of contact from him with the one of the alleged victims in this matter. He is not going to be an issue in this case anymore. She's asking for an opportunity to be out, at least on home confinement. Your Honor, she is pregnant. She advises she's not getting the most the best nutritional care at the jail, certainly. She provides that she would be fine with the home confinement. I'm concerned about her stress levels in the jail. I understand that last we were here, we discussed that on the record somewhat, so I'm not going to go into too much detail about that. She does have an OBGYN appointment on the 15th of November she would like to be able to go to, however. So I'm just asking for an opportunity for her to be on home confinement. Again, she's not going to have she has no problem not going to the football games. That's not going to be an issue for her anymore. The preliminary testimony provided that there was no contact between the two of them. I know that there won't be regardless. She's not going to be putting herself in a situation where Chloe could show up at a home where she happens to be at either, because she would be out of the area entirely.
Response.
I'll try to keep it brief, Your Honor. Your Honor, this court proceeded over bond violation hearing. I wasn't here for that, so Your Honor is more aware of the details than I am. But what I do know is that there was at least 2 clear violations. Minor victim involved who is already scared, already had to witness something terrible at the hands of this defendant, already is in a horrible situation with her father because of the defendant. This defendant is a grown woman. She needs to start acting like it and stop blaming other people. She has made decisions, despite this court's orders, to go to events that are related to the school of this minor child victim. Her attitude has been very poor regarding this matter. She has not taken responsibility by way of at least changing her behavior. I understand we're in an active pending case, so she's limited in that regard. I completely understand that. But to sit here and try to blame someone else, I have no doubt that this Travis person is doing a horrible job being a father and is doing a horrible job mitigating this situation. However, we don't have jurisdiction over him. We certainly don't have jurisdiction over Chloe, the minor child involved. And she should have to be held responsible for avoiding this defendant. There is no reason she was at those football games at all. And I have little doubt that she would continue this behavior. And I'm not sure exactly if I picked up on it correctly, but it sounds like she's going to be staying with family members of the victim because that is the biological child of Travis. So I'm not sure how that would make any sense.
I don't think it's going to work. And I hear you. And I listened to Chloe and heard everything from it. I'm not even sure why this is being raised again, because it's not going to happen. Motion for bond reduction denied. Bond will continue. I have a plea form that indicates she's going to be pleading guilty to an added count 2 of animal cruelty, 2 to 3 animals, a 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. I don't know what all this other stuff is. Restitution is waived, no delayed or deferred, and defendant must surrender all rights to all of the animals. Defendant cannot own animals while on probation. And the Humane Society of Huron Valley can do home checks to assure that.
Thank you.
That's the court's full understanding.
That's a correct statement, Your Honor. And just for the record, the restitution amount as of today is just under $107,000 that the Humane Society is willing to pay.
I don't know what she said.
In regard to what apologize.
Hold on. She said the restitution amount is just under 107,000, which the Humane Society is willing to waive.
And the surrender of the animals, the Humane Society will be bringing her the surrender forms, the forfeiture forms for all animals today. She has 24 hours from today's date. Basically, she'll be signing them in the presence of the Humane Society. That has to be done within 24 hours of now, or else we'll be moving to withdraw from this plea agreement.
Will the Humane Society come here so I can sign them in front of them? Yes.
Okay. And how many?
For the facility you're going to?
There were 6 animals, and they will be bringing her 6 forfeiture forms.
I didn't own the cat. Does that matter?
You what?
That you have to ask him, not me. I didn't own whatever. I did not own whatever cat they were talking about. I don't know what cat it was, and I didn't own any. So
It doesn't
I can't
matter. She'll
really-
still have to sign the form.
What?
That's, so, Ms. Lindo, the prosecutor explained to me that because these cats were found on your property, you have to sign that you're not wanting to keep them.
Them,
Whoa.
is it more than one?
Whose cats are they?
They appear
Nature.
to be feral cats, Your Honor.
What?
They appear to be
They
feral. Your Honor.
belong to the neighborhood. They go from barn to barn.
Okay.
In addition, the Humane Society will be coming out to her home daily now with live traps to remove the feral cat colony that is currently living on her front lawn.
They are not there now.
They'll be coming out to make sure, but just so she knows, the Humane Society will be at her house every day now.
Okay, so, folks, is this ready for a plea?
The animals, it is ready for a plea. The animals were removed from the Humane Society. They have them in their care. The feral cats are additional now. So they're ready to do what they need to do to get them off of her property.
Got it.
They aren't there. There's no cats to get.
Wonderful. Then they will confirm that and on we go.
Is that everything?
Yes, I'll stop talking now. Thank you.
And I can confirm that is everything, Your Honor.
Ma'am, if you could please raise your right hand.
I'm gonna hold it up.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I have a little difficulty with that because I'm going to plead to things that I know are not true.
They're asking if you're going to tell the truth.
I'm going to tell the truth, so help me God.
You can put your hand down. Ma'am, it's this court's understanding that you're going to be pleading guilty to the charge of animal cruelty 2 to 3 animals. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs, up to 300 hours of community service, or a combination of any of those penalties. You understand that, ma'am?
No. Am I accepting those penalties?
But you have to say that you understand that you could be given those penalties. You could be.
Okay, I understand that I could be given those penalties.
Okay, you understand that those are the maximum penalties, ma'am?
They're the maximum penalties.
Yes.
All right. And understanding that, do you still wish to plead guilty?
Do I wish to plead?
Do you still wish to plead guilty, understanding that those are the maximum penalties that can be given?
Because I'm not sure I realize and I appreciate who's ever helping her. However, I'm not sure she's understanding what I'm saying.
Yes, Your Honor, may we approach for a moment?
Sure. Okay, record should reflect we've had a bench conference in this case. Ms. Lindblade?
Yes.
What I'm going to do is I'm going to adjourn this matter out 1 week. Okay? And your attorney will be in touch with you.
What's the purpose of that? I can't plead guilty now?
Nope, your attorney is going to call you.
Your attorney will call you. And you can blame it on me because under the circumstances, I don't know that I would accept your plea today.
So he wouldn't accept your plea. So say, okay, you're going to go to
Not
court
today.
again. Okay, court a different day.
Okay, so I'm going to put it out 1 week to the 24th. And then we'll get in touch with your attorney and then we'll see exactly where we are on that, okay?
Okay.
All right, thank you, ma'am.
So Eileen, you got a good question there. How was she abusive to the cats? I think simply by not being able to take care of them, having that many cats and not being able to provide for them, also having, other animals and stuff, it's just more of a process than anything. They can't take it unless they do some sort of control over it. And Big Tiff, you're right. She's lost, and the judge did the right thing by not accepting her plea, not accepting anything she says, because she's obviously not understanding what's going on. And so, yeah, and KS not providing clean living conditions for a proper shelter. Absolutely. You know, if you can't take care of yourself, how can you take care of animals, much less that many animals? So in the end, they've got to follow the path, and you know, they can't just come and steal your property, so they have to take it through court. And so this is the path they take for it. So here, let's go to one more Judge Boyd clip, and then we were going to jump on Judge Green, and then a couple of Judge Fleischer. So here's the Judge Boyd lawyer arguing with her, and it's always fun to see the lawyers argue with her.
On this, what are we here for? Motion to revoke?
This is a restitution, to add restitution to the case.
State, are you ready to proceed on the restitution hearing?
I don't know, Your Honor, because Mr. Basile has.
I have a legal issue.
Argument.
Yes.
All right, Your Honor, my argument is that the court took up this case on May 7th, 2024, granted a deferred adjudication. At that time, the order states there's zero restitution on the court's order, the written order. And also in the conditions of probation, it doesn't have any amount. It has to be determined, doesn't have any amount on there. This notice requesting it, that I'm seeing in the printout, was filed on June 12th. It's my argument that that order that was issued by the court on March 7th became final. 30 days later, that was a final order. And since under case law I've researched and found, and I can give you the sites, the courts consider restitution to be part of the sentencing. It's my order to proceed on would be a violation of his due process, considering that as a final order by this court. And the court cannot change that. There are also the court cases I've read from the Court of Criminal Appeals says the court cannot go back and order restitution if there wasn't restitution originally ordered, or a restitution hearing that was set up to determine later.
All right, so a restitution hearing was set up on June 25th, 2024.
And I didn't see that on the printout I got from Odyssey.
Okay. Odyssey is
well, there's
incorrect.
June 25th, that's correct.
Yeah,
But,
June
but
25th.
the supplemental report asking for it was filed on June 12th. So there was not a request. There was a request on June 12th to set it, which is more than 30 days after this court sentencing. That sentencing order became final after 30 days.
All right, so then honestly, what the issue is that the judgment that was issued is not a correct judgment. And let me explain to you why it's not a correct judgment. When I accepted the plea bargain agreement, I sentenced him to $2,000 fine probated, 200 hours of community service restitution. He was either obtained his GED or a certificate from a trade school, and the community service hours were deemed satisfied. Took into consideration County Court 12 cause number. And then I ordered that there was restitution to Kenyana Warner in 708710. And that was ordered on the record. So the problem is the judgment is incorrect, and there needs to be a correction of the judgment. I mean, we can't stay with an incorrect judgment.
It was still being argued that that judgment is final, and I can give you the case law.
No, I understand what your case law is, and I understand what you're saying. So everybody step back. All right, thank you.
Exactly which ones. Some of them were on verification, the cases I was
All
told
right,
the
if you
court
want
have sites for, so.
All right, if you want a chance to read that, you can, but from what I reviewed, it appears that I can give restitution in this case.
That's fine. I mean, I'll take exception to your ruling, Your Honor. I think.
Well, no, I mean, do you have some case law
Well,
that,
I have
that addresses 42.037?
I have case law that, yeah, I can get you the sites. I have them here on my computer.
All right,
Yeah,
sure.
Yeah, we can write them down and give you the sites.
Okay, awesome.
Yeah.
All
Okay.
right, just step back.
Eviction is final, or the other deferred is different. I understand kind of the law.
So if you would like, I can make my ruling now for both parties. And from what I've read, I still have jurisdiction to order restitution. I don't know if y'all have agreed on a restitution amount, but what I can tell you all is that I'm not going to order her to go through her insurance if she
And-
doesn't want to go through her
And I
insurance.
agree with that, Your Honor. I researched that issue. That was an issue last time. I could not find any case law that says she has to do that.
All right.
The only case law I could find, if she did, then that's credit against his. I didn't find it required. I explained that to my client. So
So-
that is correct.
So then the question is, have you all agreed on an amount of restitution?
No, Your Honor.
I don't know.
All right, if you all want to confer and see if you all can come up to an agreement on the amount of restitution, like I said, based upon my review of the case law, and I re-reviewed.
Yeah.
And based upon the article I gave you, I'm of the opinion that I do have the right to still order restitution. So we're just now at an amount what it should be. And I don't think anybody has to use their insurance if they want to be. So the restitution is not just her deductible. So
And I agree with on the insurance part, Your Honor. I'm not objecting that anymore. I researched that issue. On the other one, I'd just like to make on the record, so in case my client wants to do something, he'll have a record on it.
okay, so then let's do this. Let's see if y'all can come up with an agreement on restitution amount, and then I'll allow you to put whatever arguments you want to put on the record so you can make your argument. All right, thank you. All right, we're back on the record in 2024 CR 1043 State versus J. Juarez. And if you all could re-announce for the record, please.
Carl Basil for the defendant, Your Honor.
All right. And Mr. Basil, the court had considered your argument. The court reviewed Article 42.037 with regards to restitution, and based upon that article of the courts, it's in the court's opinion that the court can still order restitution in this case. And I'll let you place on the record whatever you would like to place on the record as it relates to that. And
Yes,
then
Your
we'll
Honor.
speak towards the restitution.
It's the defendant's position, Your Honor, that since this court granted the deferred adjudication on March 7th, 2024, and at that time in the court's judgment, there was restitution was listed as 0. And on the conditions of probation, there was no amount of restitution listed. That by rule of law, that order became final after 30 days and became a final order, just like if the defendant wanted to appeal, he didn't want deferred adjudication, he would have to have filed that within 30 days. On June 12th, the supplemental request was submitted set the case for restitution hearing, which is more than 30 days after that, and is the defense argument, Your Honor, that the court at that time does not have the authority to go back and change the judgment. And I've submitted some cases. I wrote them down. My computer's battery's about dead here, so I'll have to read them off the paperwork Your Honor gave you.
Yes, no problem.
Cases that I researched, and while there's not directly, so the court knows they're not directly on issue because they're mostly talking about probation. And I understand the statute that you're talking about mentions probation. Most of the time, there are some places in there it does talk about deferred adjudication on there. It's Cox v. State, 445 Southwest 2nd, 200. That's the Texas Criminal Court of Appeals, 1969. Bailey v. State, 160 Southwest 3rd, 11. It's also Texas Court of Criminal Appeals, 2004. Ex parte Cavazos, 2003 Southwest 2nd, 3rd, 333. Texas Criminal Appeals, 2006. And ex parte Roberts, which is 409 Southwest 2nd, Southwest 3rd, 758. Texas Appeal, San Antonio, 2013.
All right.
Those are the cases that were provided on the notes to the court that I'm relying on, other than just the general, also under under notice provisions under due process clause, United States Constitution, the 5th and the 14th Amendment, and the Texas Constitution, Article 1, Section 19, which requires that he be given due process before any life, liberty, or property is taken from him. And it's our argument that since that order was final, the court does not have the jurisdiction to do that.
All right. And the court will note for the record that on March 7th, 2024, as a part of the plea bargain agreement, the court ordered that restitution was to be determined to Kenyana, Keyana Warner, And according to the plea bargain agreement, the plea bargain agreement stated that restitution was to be payable to Kiana Warner, the victim in cause number 708710. That was a part of the plea bargain agreement that was agreed to by Mr. Juarez on that day, and that is a part of the contract that he signed. With regards to the judgment stating that no restitution, it states $0 restitution. The court is finding that that was an error. It should have been that restitution was to be determined. And this case has been reset more than once for both parties to come together to see if there is an agreement on restitution. The first restitution hearing was scheduled for June 25th, 2024. Then it's reset for July 18th, 2024 for the state to obtain proof that the complainant did not use insurance. And that was at the request of the defense because the complainant had a deductible. Then it was recalled for August 1st, but defense attorney was ill. And then it was recalled on August 1st because the defendant was ill on July 18th. And then on August 1st, we were to have a restitution hearing and a witness was allowed to appear by Zoom. And now we're here on September 12th. So have you all come, the court has received documentation of a preliminary estimate for restitution. And they put that total at $6,399.22.
That's correct, Your Honor. I've received that. I've reviewed that with my client, and my client is desiring to have a hearing and evidence presented on that amount. I've discussed that with him in detail last time and further detail today in the courtroom.
All right, state, you'll need to have witnesses here then for this being the amount of restitution.
When you're on.
How long will it take you?
I will need to ask Ms. Warner, so I don't know right now.
All right, so what we're going to do, and this is going to be the last setting that I'm giving everybody for restitution.
Just so the court knows, Your Honor, I will be out starting tomorrow through next Wednesday. I'm having a medical procedure done tomorrow, and I'll be back. So I'm just.
All right. Do you want to do it? Is October 21st good for you or no?
No, that's fine. I'll be back before then. I just want to let the court know if you want to do it next week, I'll be out.
Okay, no problem.
And Your Honor, I should be able to secure it by
All right, Norma, this case is going to be recalled October 21st, and this will be the last setting for restitution.
Your Honor.
Yes.
Will Ms. Warner be allowed to testify via Zoom if there is no objection from defense counsel?
I have no objection to that.
All right, she'll be allowed to testify by Zoom. All right, thank you.
I think I picked the one time I actually agree with something Brecken said. Yeah, this guy looks like he's just bored as could be and looks like he's just going to keep doing what he wants to do. It's only $7,000 restitution. He's lucky that that's all it is. He should just take it and run with it, but he wants a trial for it. I think that's one of the flaws of being allowed to have being able to have free legal representation. If he didn't have free legal representation, the lawyers would cost him more than $7,000, so he'd quickly agree to the deal. But since he's not planning on paying anything, might as well. It says Allie's asking, why does he have a Puma on his tie? Is it 1987? I don't know. That's what that is, Allie. I don't know what he's got on his tie, but it's not 1987. Let's look to Judge Green. Let's look up Judge Green. Hold on, I got another one up in Michigan too. So it's in Monroe County, Michigan.
Mr. Hickok, are you facing any criminal charges this morning, or are you be held simply on this front of the court bench warrant?
Just this bench warrant, Your Honor. I just came back from Florida a few months ago. I was down there incarcerated, and then this warrant came out, and I don't know. I haven't. It was just for this, as far as I know.
Right. What's your current mailing address, Mr. Hickok? An obligation to keep the front of the court informed of any change of address. So when you receive a notice to appear because you're not keeping contact and you don't appear, that's when bench warrants issue. So it's sort of on you, Mr. Hickok. Are you currently employed?
Yes, Your Honor.
With whom?
I'm a mechanic.
Okay. When did you last work?
I've been off for 3 weeks because of a broken collarbone.
Okay. Do we still have a job when you get out of jail?
Yes, sir. Yes, sir.
Okay. How have you been supporting yourself in the past 3 weeks?
My mom, my grandma, my girl.
Okay. All right. Hopefully they can post a bond on your behalf, Mr. Hickok. When you get released from jail, you need to come over to the front of the court and fill out a change of address form.
What do you say?
So when you get released from jail?
Well, Your Honor, the reason I was incarcerated for the last 3 years, and for my notice of appear, that last address you had, I did a Zoom meeting when I was in Monroe County Jail before I got extradited down to Florida. And I was supposed to go to court in February, but that was like 3 years ago. I had just came home and started getting things back around. I found out I had thyroid cancer and other things. I had just came back home, Your Honor, and then this popped up. I didn't know. I've been trying to work with everything. I'm taking care of everything down in Lenawee County that I've had to take care of my past stuff. I mean, I'm trying, Your Honor. I have been incarcerated for the last 3 years.
Provide the court some information about Mr. Hickok in this particular case, please.
Yes, Your Honor. It appears that we were aware he was incarcerated, but he was released from incarceration. I believe it said May of 2024. This warrant was issued October 15th of 2024 from a referee McKee hearing. This is an arrears only case because of his incarceration. His support was abated. The arrears on the case is $11,082.92. And Mr. Hickok was found in contempt on December 18th of 2020. It was a first finding and he has a 40-day balance.
Mr. Hickok, is your collarbone now repaired? Can you go back to work, or are you still going to be off for another week or two?
No, I can go back to work as soon as I can. I mean, I'm on light duty because I was supposed to be in a sling, but I can still do other things. My boss has been allowing me to go back to work, but if I miss much more, I don't know. Excuse me.
Why haven't you been back last week?
Have I been back the last week? Light duty, yes, sir.
Well, you said you've been off for 3 weeks. Now you're saying you're back on light duty?
No, I'm going back Monday. I was supposed to go back Monday. I apologize because of the holidays and everything. I go back Monday for light duty, sir. I'm sorry. I forgot what the days were. This has got me confused.
Well, you've got 40 days hanging over your head, Mr. Hickok. So in order to get released from jail, you need to post a cash bond. So this is where you reach out to your grandmother, your mother, your girls.
They don't have nothing.
That cash bond.
I'm going to lose my job. I'm going to lose everything now.
Okay. How much can you post?
Maybe a couple hundred, sir. I have the holidays and everything. I just came. I'm going to be going back. Matter of fact, if you give me till next Friday, sir, I will give you $500. I'll give you the first week check, sir.
It doesn't work that way, Mr. Hickok, because we don't have.
That's the only way, because I don't have no money to work for. I have to work for my money.
The court is not convinced you return with the payment, Mr. Hickok, so you need to post a bond, cash bond. Ms. Pratt, what's your recommendation? Or do you have any questions, first of all, for Mr. Hickok?
I do have a question. Mr. Hickok, when were you hired at Intuit Auto Sales?
2 months ago.
Do you have a date?
No, I don't know the exact date, ma'am. I'm sorry. I've had so much medical going on. I don't know.
Did you notify the friend of the court that you were employed?
I had sent a message. I had sent an email or tried calling because it's been all confusing because of my incarceration, ma'am. I'm not gonna lie to you. Sorry. And find out thyroid cancer and everything else. I've had a lot going on, ma'am. But I have tried contacting my people. We've all tried contacting. I didn't know where to look at. The last letter I received from you guys is when, oh my God, I was incarcerated in Florida. And something child protective services happened at the house that my son's at. Even he's not with his mother or something. He's with his grandparents. That's the last thing I received. Okay. I do know I owe in rearages. I've only been working for a couple months and then I just got injured again.
Mr. Hickok, when did you come back to Michigan?
August.
I
came back in August.
Honor.
I found out I had thyroid cancer. They've been trying to put me on disability, but I've been trying to work because I have thyroid cancer and my rheumatoid arthritis, but I am at least trying to work. But now I'm not going to have a job. So,
right. Well, Mr. Hickok, you've been sitting on your hands. If you're, after you've been working, you've not paid one dime toward your child support in recent weeks. You've not made any contact with the front of the court. If you would have contacted the front of the court, say, I've got thyroid cancer, I've got a collarbone break, I've got this and that, and update the address, and the front of the court will work with you, but you've totally ignored the front of the court. So
because of everything going on in my medical, Your Honor, I am sorry. I've been taking care of that and a place to live, trying to find a place to live. I've been trying to do, I'm actually for once not on probation or parole in my life. I've been trying to do the right things. I am out there working. I'm trying to make a living for myself so I can actually take care of my son. I'm trying these for once. I'm 47 years old. I have never been out of prison this long in my life, and I'm actually staying out. And
right. That's good. Mr. Hickok, all you need to do is come visit the front of the court. Come down.
Is he bragging that he's never been out of prison this long in his life? Seems like prison should be the minimal part of your life, not the normal.
And see someone. Very simple. You don't need to apologize. You're simply.
I know. I'm saying I have no license either. I don't have no license or go car.
All right. All right, Mr. Pratt, what's your recommendation this morning?
Your Honor, front of the court would request 7 days immediate credit for the 1 day because it appears that Mr. Hickok was arrested yesterday with a $500 cash bond.
All right. To Mr. Hickok, anything you want to say before the court imposes a sentence?
I'm trying, Your Honor. I'm actually for once trying in my life. Please give me a chance to try.
Well, it's a pretty reasonable recommendation, Mr. Hickok. So the courts will follow the recommendation. It's very reasonable. You can be home for dinner if you can post $500 cash. So you make some phone calls today. The sentence of this court is you ordered to serve 40 days in Monroe County jail as follows: 7 days immediate. You're giving credit for the 1 day you have served. So that means you're going to serve the next 6 days in jail, but you can cut that short by posting a $500 cash bond.
I have to work.
Keep in mind, you still have 33 days to have your head. You can avoid the additional 33 days by keeping in contact with the front of the court. When you get released, even if you serve the 6 days, Mr. Hickok, come over to the Monroe County front of the court, change your address so you get a future notice, and keep the front of the court informed. And you need to make some payments. And finally, I'm going to give you a date for review. Ms. LaPrade, what do you suggest for review date?
February 11th at 1 p.m., Your Honor.
Okay, Mr. Hickok, you ordered to appear.
I'm supposed to have surgery on the 10th.
Your Honor, we can push it back to February 4th.
Okay. All right, Mr. Hickok, you ordered to appear before the front of the court February 4th at 1 p.m. You can appear via Zoom if you're working. February 4th at 1 p.m. Either in person or you can appear via Zoom. A copy of this order will be sent over to the jail. You get a copy of this before you're released. And if you want a copy mailed, you need to provide the front of the court with your new address. Do you have any questions, Mr. Hickok?
What do I do when I don't have a job when I get out to be able to pay?
That will conclude this matter. You just got to pay attention, be proactive. Mr.
I understand,
Hickok,
but now when I get out and don't have a job, what do I do for paying for not having a job?
Hopefully, if you're a good employee, your employer will hire you back. Maybe between
he's already said he can't wait that long,
and your family,
because
they can help you post a $500 cash bond. So you got to be proactive.
Nobody can. It's the holidays.
All right.
It's the holidays. So now I'm just might as well just sit in here the whole time. Is that because I'm not going to have a job? I'm not going to be able to afford $500. If I go back to work Monday, I can pay $500 on Friday, Your Honor. I'm trying to work with you guys. I'm trying to explain to you. I'm for once finally trying to do something right.
If you would have done something right, you would have contacted the court ahead of time, Mr. Hickok, before being arrested.
I don't know this, Your Honor. I didn't know this. I thought they had my address because they sent me mail down to the prison when I was down there. That's an address I had after the last address you guys had for me. So I figured you guys knew what my address was. I didn't know. I don't know this stuff. I'm finally trying to do stuff right for once in my life. But this is the stuff that makes me want to just say, screw it.
Okay, well, you're just gonna dig the hole deeper, Mr. Hickok. So in any event, call your family and friends, tell them that you can repay them in a week when you get paid. So hopefully they can advance.
I have no phone calls, Your Honor.
So that will conclude this hearing. You can zoom out. We'll send copies order over to the jail. Thank you, Mr. Pratt.
Thank you, Your Honor.
So I was thinking about his, he's a mechanic on light duty with a extensive criminal past. I don't know why. He's certainly not going to be able to get another job. Nobody would hire him. I doubt he's working anywhere as it is, but I don't know if I were any shop, the company I work with, we have a shop and we wouldn't take on that sort of liability. We wouldn't take on that sort of trouble. So I can't think of where in the world he's going to be able to find a job at that's going to be reputable. I don't know. Either way, I think Judge Fleischer said Amazon's always hiring, so go work at Amazon warehouse, buddy. Speaking of which, let's look at a little Judge Fleischer from Friday. So here we go with that.
Good morning, Mr. Allen. Sir, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Hey, senor, hat off. We're going to do probable cause. You have the right to remain silent. Anything you
Eileen, that was a child support rearage. He was behind $11,000 on child support. So that's what he did there.
say can or will be used against you, you have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge.
Okay.
On December 28th, 2024, the officer came to a stop behind the defendant's vehicle and the light turned green and the defendant's motor vehicle proceeded and the defendant's vehicle immediately drifted approximately halfway onto the shoulder with other motor vehicles around it before the driver jerked back into the lane. Traffic stop was then initiated and the officer made contact with the defendant, the driver, and sole occupant of the vehicle. The officer observed slurred speech, bloodshot eyes, unsteadiness on feet, and an odor of an alcoholic beverage. The defendant admitted to consuming one alcoholic beverage and standard field sobriety tests were administered. HGN 6 out of 6. The walk and turn on one leg stand could not be performed due to the defendant complaining of leg pain. The defendant was read the DIC and consented to breath. The result was 0.192. However, the defendant was unable to provide a second sample and consented to a blood draw.
Mr. Allen, I'm going to find that there's probable cause to go forward with your case. Does he have a license?
Eligible, Your Honor.
All right. How many prior DWIs does he have?
He has one prior, Your Honor.
One? Okay. Mr. Allen, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. You have a valid license. You cannot drive unless you also have valid liability insurance in your name, and I'm now placing a restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If you're caught driving a vehicle that doesn't have an interlock, I will revoke your bond, put you in jail. Do you understand? I'm sending word and notice to DPS so that every police officer in the state is going to know if you get pulled over and you're driving a vehicle that doesn't have an interlock, they're going to arrest you on the spot. Do you understand? I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Stewart and he will tell you when you have to come back to court. You don't have to waste your time coming back here, but you must stay in touch with counsel and he'll tell you when you have to come back. You understand?
So I need to wait for him now?
We're gonna have you wait for him now, but after today, I'm gonna waive your appearance so you don't have to waste your time. We'll just have you work and do your life while we get evidence, or while he gets evidence to work the case up.
Wait for him.
Right, I'm gonna have you sign a reset. I'll have you meet with Felicia for bond conditions and we'll just have you waiting back for Mr. Stewart to show, okay? Please.
Right this way. All right, Judge, next is page 2, Viagas, Raquel.
Good morning, Mr. Viagas. Sir, you're charged with failure to give information upon striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, Judge. On December 28, 2024, the officer was dispatched to apartments in Harris County, Texas, in regard to a single vehicle accident that hit the mailbox of a residence. The officer observed the defendant's motor vehicle with heavy front end damage, but did not locate any driver or occupants inside the vehicle. During an inventory, the officer located the defendant's photo ID and Texas utility bill that came back to the defendant's name and address, approximately 1.4 miles from the accident. The registered owner of the mailbox the registered owner came back to the defendant of the utility bill and his address. The officer went to the defendant's residence, noticed the garage door open and garage interior to the residence wide open. The officer made contact at the residence, one to make sure the motor vehicle was not stolen and one to make sure the owner of the vehicle was okay. The officer went inside the residence after knocking and announcing his presence several times under the community caretaking doctrine, and the officer made contact with the defendant asleep in the living room. The defendant woke up in an...
Whoa.
Yes, Judge. It was because they had...
Whoa.
Yes, the vehicle was damaged and he wanted to make sure the driver was okay. So he announced himself and went into the residence because the door was wide open.
Wow.
And then it was after that he saw the defendant asleep in the living room, and the defendant woke up and immediately said the car accident, that he did not cause any injuries or any trouble, and that he was driving his motor vehicle 2 to 3 hours prior, and that he was on his way to drop it off at a mechanic when his vehicle was hit. The defendant called the insurance company, and the defendant walked home because no one arrived on scene, and the defendant was going to pick up his motor vehicle in the morning. And the officer made contact with the complainant, who stated she heard a loud bang and observed damages, approximately $1,025.
So are you telling me that he did stay though?
No, what happened, Your Honor, is that he struck the mailbox at the apartment, and the defendant said that he called his insurance. No one came to the scene, so he walked home. And the officer, when he arrived, saw the empty...
Did he make an attempt to make a phone call at the scene to anyone?
All he said is that he called the insurance company. That's the only person that he had stated he called. And then after that, he walked home because no one arrived on scene. And then that's when the officer arrived and saw his empty vehicle damaged. And then he found a utility bill and the ID.
I have so many questions. Let's do this. I'm going to appoint you a lawyer, or you have a lawyer, right? Let's do this. I'm going to hold off on finding probable cause at the moment. Let me wait for your lawyer to get here. We'll revisit PC and here momentarily. Just go ahead, take a seat for me if you don't mind in the jury box. Yeah? Let's wait for your lawyer to get here and then we'll go forward.
Yes,
All right,
sir.
Judge. Next is page 3. Brunston, come on up.
All right. Good morning, Mr. Brunston. Good morning. Sir, you were charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. The officer is dispatched to a disturbance at a residence in Harris County, Texas. And the complainant, the mother of the defendant, told officers that the night before, her and the defendant had gotten into an argument. The defendant returned the next day to get his belongings, and the defendant walked up to the complainant with a fighting stance. And the complainant told officers that the defendant grabbed her wrist, causing pain and scratches, and attempting to pull her. The defendant stated, "No, bitch, you're coming downstairs with me." The complainant pulled away, and the defendant then slapped her in the face, causing pain. The witness, the defendant's sister, also saw the assault.
Mr. Brunson, I'm going to find that there's probable cause to go forward with your case. No, now's not the time. You will have the opportunity. Now's not the time. I'm just trying to find if there's enough probable cause to go forward. If so, what kind of conditions to put on your case, if any? Have you reached out to the complaining witness? Do we know what she wants?
So we made an attempt and she couldn't speak to us at the time we called, so we'd have to reach out.
Okay. Mr. Brunson, because I always like to follow the wish. Stop. I'm letting you know what the expectation is in this court. You have the right to remain silent. Exercise that right. I've got a bunch of DAs here. Whatever you say, they're going to sit there and type it and use it against you. I like to follow the wishes of the complaining witness. When I don't know what they want, I'm going to order you not to have any contact with them. I'm also ordering you not to be in possession of any weapons as well. There is a protective order that has been issued in this case, and if I were you, I would get to know it, because if you violate the protective order, the state can and will file additional cases against you, including a violation of protective order, and that is the capital murder of misdemeanors. Do you understand? So get to know it. We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria and sign a reset. We will have you take a seat in the jury box while we get your bond conditions ready, while we sign it, and after that, you'll be free to go. All right, please. Ms. Bryant, ma'am, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes, Judge. The officer was driving on Katy Freeway in Harris County, Texas, when he observed the defendant's vehicle driving at a high rate of speed, rapidly accelerating, making evasive lane changes and aggressive maneuvers without signaling, cutting off multiple vehicles, and making those drivers take evasive action to avoid a collision. While the officer was attempting to catch up to the defendant, he reached speeds in excess of 120 miles per hour. The officer then conducted a traffic stop, and the defendant stated she was driving that way because she was late to work.
And I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid Texas driver's license? Okay. If I find that you drive like this again, because I'm making a bond condition that you're not to drive like this, if I find that you do, I will take your privilege to drive away from you while this case is open. Do you understand? Living in a city as big as Houston without the ability to drive is absolutely awful. Don't. I'm going to protect my city at all costs, and if I have to put you in jail because of it, I'm going to have you sign. How old are you, ma'am? Okay, we're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign and reset. After that, I'll have you take your seat in the jury box. I'll get your bond conditions, no racing, reckless driving, anything of this nature. After that, I'll have you sign it, and then you'll be free to go. All right?
Has anybody seen court or anywhere else that does the street racing and street takeovers and stuff like that? Houston has quite a bit of them, but I don't know that I've ever seen it anywhere else. But I have driven through Houston, and 2 and 3 o'clock in the morning, it's a racetrack. You know, during the daytime, it's normally a parking lot. But I've been through there in the middle of the night, and it's just I don't know how in the world people drive so fast through there. I'm just a wimp. I don't drive that fast under any circumstances. But people love to do it. I'm always worried about something in the road that's going to tear up the tires, and I'm just too cheap to buy tires. But there's people there that have no fear in life, so they run the streets.
Next is page 5, Galden, Kendall.
Good morning, Mr. Galden. Sir, you were charged with unlawful carrying of a weapon, and you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On December 27th, 2024, the officer observed the defendant's vehicle failed to maintain a single lane and veering over the left lane on 3 separate occasions. A traffic stop wasn't conducted, and the officer made contact with the defendant, the driver of the vehicle. The defendant advised he was unlicensed and that the motor vehicle was not insured. The officer observed a strong odor of marijuana emitting from the passenger area of the vehicle, and the defendant voluntarily produced a partially burnt marijuana cigarette and stated it was the possible source of the smell. The officer conducted a search of the defendant's identifying information, which yielded an open felony warrant for continuous violence, and a search of the defendant's left jean pocket yielded a clear plastic baggie containing a green leafy substance. The substance was identified as marijuana based on training experience. The defendant's motor vehicle was searched incident to arrest and yielded an unholstered AR-15 pistol on the front.
AR-15?
AR-15 pistol, Your Honor. And the defendant acknowledged ownership of the firearm and stated he used it for protection since his brother is a famous rapper.
Find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I'm going to put you in jail. Do you understand? You do not have a Texas driver license. You are not allowed to drive. You will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in this life. I don't care where you got to go. I don't care what you got to do. If you don't have a license and liability insurance, do not drive. Do you understand? How old are you, sir? What do you do for a living? Why?
I don't work.
How do you support yourself? How do you support yourself?
My brother supporting me out. I ain't go out looking for a job yet.
It's time. I will provide you a lawyer today, but it's time to get a job, a full-time job. When you have too much time on your hands, you become self-destructive. Not here. Do you understand? All right. Do you mind giving an application, please? I need you to fill out an application for me. I'm going to have you sign a receipt of Victoria. I'm going to have you meet with Felicia for your bond conditions, and then we're going to go. I'm going to get you on the right track, Mr. Galden. Come on.
No driving after.
Judge, no firearms?
Correct. No weapons, no drugs, no alcohol, random UAs, no driving. Did you graduate from high school? Did you graduate from high school? Did you graduate from high school? We're going to work on that. Hey, homeboy, 2 weeks for working on GED as well. Good morning, Mr. Gunder. Sir, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you. Do you have a lawyer, sir? Okay. Who's your mom? Is it? Okay, let's do this. I'm just gonna have you take a seat real quick, okay? Just take a seat for me right there on the first pew, okay? Thanks.
All right, Judge, next is page 6, Gutierrez.
Oh, that's.
Page 6, Harvey, come on up.
Good morning, Mr. Harvey. Sir, you're charged with reckless driving. You're facing up to 30 days in jail and or a $500 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. The officer was parked and observed a road rage incident occur. The officer observed the defendant's vehicle laying on his horn and speeding up to cut off another vehicle. The officer observed the defendant slamming on his brakes, and the driver of the other vehicle then attempted to drive around the defendant when the defendant cut her off again and slammed on his brakes, nearly causing her to drive into a ditch and nearly causing an accident with other vehicles. The officer then initiated a traffic stop and pulled into a nearby parking lot.
Mr. Harvey, I'm going to find that there's probable cause to go forward with your case. Patience. Patience when driving. And I'm going to have you sign a document promising me that you're going to exercise this patience and not drive in this manner again. And if I find that you do, I'm going to put you in jail. Do you understand? How many times do we have people on the road that sit there and get shot because of the incidents like, don't drive recklessly. File those conditions like we did in the other case.
Yes, Judge. Yes, Judge.
Harvey, we were going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. We'll then have you take a seat in the jury box. We'll get your bond conditions. We'll have you sign it, and then you'll be free to go. Wait, does he have a Texas? Can you run his license, please?
Expired. I see eligible on RN. I can run it again.
Please. If you do not have a Texas driver license, then do not drive. I will have you sign an affidavit today with me promising me you're not going to drive unless you have a valid Texas driver license and liability insurance. It is your responsibility to reach out to DPS to figure it out. Do you understand?
Yes, I see eligible on our end.
Okay, I'm going to have him sign it. And then if you do, if you have a license and liability insurance, you can drive. If you don't, then don't. If I catch you doing it, it's not going to go well for you. You understand? Okay.
That's right. It's always good for karma for the police to be right there and catch you doing something dumb like that to somebody. It's bad enough on the road with bad drivers, but then you have people that are aggressive on purpose. It makes the roads terrifying. Nan always talks about Interstate 40 going to Nashville, and that's a road where on the best day, you get 5 to 10 accidents on your way to work.
Why do we have her in custody? What happened? Okay. Gutierrez. All right. Good morning, Ms. Gutierrez.
Good morning.
Ma'am, you were charged with driving while intoxicated, second offense. The reason that we are taking you into custody now is that it looks like you're on probation for a felony retaliation case, which is
That's odd. It looked like it paused to me.
now set at no bond. So we're going to do probable cause here today. If there is enough,
I'm sorry, I can't hear.
you're on felony probation. Looks like a warrant has been issued in that case. Bond is set at 0. So we'll do probable cause here. If I find probable cause, well, either way, we're going to, provide.
I don't know. It looks to me like my video's froze, but it sounds like it's still going. So I don't know. I'm gonna click out of it and see if I can't click back into it. Let's see where we go. So let's see.
Mr. Hickok, are you facing any?
Provide your lawyer today, but for now, we'll do probable cause on your DWI second. You're facing up to a year in jail and or a $4,000 fine.
Yes, Judge. The officer initiated a traffic stop in Harris County, Texas, after observing the defendant failed to yield to a right-of-way in an intersection and for driving with an expired registration. Upon contact, the officer observed a moderate odor of an alcoholic beverage and slurred speech. The defendant admitted drinking 2 beers and standard field sobriety tests were conducted. HGN 6 out of 6, walk and turn 5 out of 8, and the defendant refused to do the one-leg stand. The DIC was read and breath was consented to. The results were 0.139 and 0.146.
All right. Have you seen whether she has a valid Texas driver's
It's not eligible, Your Honor.
All right. Ms. Gutierrez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to drive. It is a condition of your bond, and you will be signing an affidavit with me today promising me you're not going to drive. I don't care what's going on in your life. If you drive, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Now, I don't know if you're going to get out of custody, but if you do, you will be required to obtain a handheld interlock device that you're going to take with you to prove to me that you're not consuming alcohol. We will also be sending word to DPS so that every officer in this state knows if you're in a vehicle driving, you will be required to have an interlock in that car. So if they catch you driving hard that doesn't have an interlock on it, you're going to be going right back to jail. You understand?
Okay.
No alcohol, no drugs, and I'm going to randomly test you as well. We will provide you a lawyer today so that you can talk with this person to figure out how we go forward with the case. All right, come on, we'll have you sign this and then we'll have you sign your conditions, man.
I think I'm going to end it there. I think we've had a long night and it's Sunday night, so we got to get ready for work in the morning, or at least the lucky ones get up and go to work early in the morning. The unlucky ones just have to enjoy their day. So, but thank you all for coming out. Thank you all for your support and for all the great comments. We should be putting out some videos this week, and make sure to always like and subscribe and all that other stuff. I'm not sure what it does, but I'm told it's important. So you guys have a great night, and we'll see y'all tomorrow.